States versus Dehlinger. Mr. Means?
May it please the court. Good morning, Your Honors. There's two books, copies of the books in those transcripts that y'all have, and there's an author in both of them, and the same author is Tara LeGrand. Tara LeGrand is one of three authors by the only product that AAA ever created, and she's also the author of a romance novel describing her adventures with the attorney who was later assigned to represent Dr. Engelhardt.
You said Dr. Engelhardt. Of course you meant
Dr. Dehlinger, and I apologize, Your
I
Honor.
was just looking to be sure that I wasn't
No,
wrong.
it's a birth defect. I do that with faces and names, and I appreciate the court's indulgence. I'm glad there's no jury here to hear it. I've done that in front of juries before. We've been pro bono on this case for 6 years, and so the two names we keep reading, anything we read on either of the names pulls up, and they're both in the name. Dr. Dehlinger was a victim. I mean, he's a victim. He's actually acknowledged in those sheets as a victim, and as I just finished reading the Stitt case, if I'm pronouncing it correctly, this morning, where the court did not grant a reversal, but it was talking about money and the worries about money. And I noticed, like the second time this week that I was reading that 2,000-page summary on page 120, the number one person that would profit on the government graph from approximately $250,000 would be Tara LeGrand. Now, on the next page of the indictment, she's number 3. But the $250,000 stood out because that's the amount of money that Dr. Dehlinger, cash money invested in this organization, and was cheated out of, which had counsel done something about that at sentencing, it might have significantly reduced the sentencing. It might have offset the taxes that were due. You took a one-semester ethics course when I went to law school. Now you're required to take a bar exam, and an ethics bar exam. So now we will eliminate all unethical lawyers. The bar exam rules start to ratify these conflict issues stronger and stronger and stronger. And I guess as we practice law, we start to see them too, how lawyers make decisions based on potential conflicts. But here's a decision that cannot be made and could never have been made. The longtime attorney for Tara LeGrand, who suckered Dr. Dehlinger into this scheme to begin with, who prevented him from going to other attorneys or CPAs when he was questioning it after his home got raided, and they did an armed SWAT squad on his daughters and his wife and him, and he was scared. And she still reassured him and kept him involved, told him it was perfectly legal, over and over and over and over again. In order to win one of these, as Professor Freeman points out, and Professor Freeman is one of the top ethics professors in the United States, but he's also, interestingly enough, licensed in the tax court and was familiar with these type of cases and the ethical conflicts. In order to win, it's pretty much standard procedure that the person that got you in trouble takes the stand, and they either side with you and say, I believed it was legal, or they say, I tricked them, or they say, I've pled, et cetera, et cetera. But you can't win one of these cases without one of the people put this together. The cheek stand says, what do you believe in your mind and your heart? But you have to prove that to a jury. And the truth is, the jury starts off thinking that, well, we don't presume innocence. We're going to require them to prove that they really believe this stuff, especially if it's difficult to believe. So These three people were all secretly represented, all three authors of the AAA book, Tara LeGrand, Gary Kuzel, and Collis Red, were all three secretly represented by Engelhardt. Engelhardt knew that. The government knew that. AAA knew that. Nobody else knew that, ever, until these affidavits started coming out. Now, they did know that he had represented Tara LeGrand, that he had gotten a mistrial for Tara LeGrand. Tara LeGrand, in her romance novel, says that he's the greatest lawyer on the face of the earth, and it is only his work that did that. There were two other people that got mistrials, and Tara LeGrand's book says that they were incompetent. And
She ultimately pled, is that right?
yes, she did. She ultimately pled.
So this trial didn't get her too far.
No, ma'am, it did not. She did 24 months in prison. When she testified, though, she testified that she told all of the AAA people, and this is really important with Dr. Dehlinger because she prepared the amended return on which he was sentenced, and she prepared the third return on which he was sentenced and
So
convicted.
did she commit perjury when she testified, or did she commit perjury when, under oath, she tendered her guilty plea in the Western District of Washington?
Only God knows for sure. She may have done it both times. She may have at one time believed this was legitimate. She may never have. She told so many lies to us throughout this. She definitely...
So how can, in light of your answer, which I appreciate, how can it realistically be said that calling her was an objectively reasonable alternative approach to the defense in this case?
Because, and the government wins...
Put slightly differently, what lawyer, frankly, in his or her good mind, would ever have called Ms. LeGrand as a witness?
Well, I definitely would have. And I did subpoena her, and I also put planners on during the trial in Seattle, and we won acquittals in all counts. And I definitely would have put her on in this case because she had said that they all believed it was legitimate. The jurors either would have heard her say, I believed it was legitimate and I told them it was legitimate, or gone by her confession, I knew it was a crooked thing and I sucked these people in, but I did tell them it was legitimate. Doesn't matter.
She could have said, it was a fraud, and they knew it was a fraud. Everybody knew it was a fraud. That's just as likely.
Well, yes, Your Honor, she could have said that, and thank goodness this court suggested that there be a 2255 hearing, and at the hearing she said exactly, she testified under oath, and she said that she told everybody that it was legal. It's in the transcript in front of you right now.
In response to my colleague, you just told me we aren't ever sure when she's telling the truth. So who knows what she would have testified if she'd been called at trial. She has so many inconsistent versions of what her testimony is.
The court is correct. You cannot guarantee the testimony accuracy or decency of the testimony of a perjurer any more than you can the perjurer, Mr. Engelhardt. But we do know this. She would have had to say something. It's very difficult.
Well, actually, we know what she said when she was called, and that is, I invoked the Fifth Amendment.
Well,
right?
No, not at the 2255.
No, I'm talking about in the subsequent trial where she was subpoenaed and put on the stand.
She invoked the Fifth Amendment. There was no ruling on whether she had a right to do it. And the reason why is she didn't prepare the people's returns in those cases. She wasn't as critical a witness. And so other people that gave the same speeches that Tara LeGrand, including Collis Red, by the way, who testified in the 2255 hearing and was never called, including he, testified at that trial, and the Moran's were acquitted. And they were acquitted because the jurors had someone to say, other than the victim, these people, these experts told me it was legal. It would have been impossible for her, actually, it would have been impossible for her to say that she never told anybody they were legal because she pled guilty to telling people that the plans were legal when she, in fact, didn't believe they were legal. So part of what she pled guilty to was exculpatory for our purposes. If I have a CPA that gets up on the stand and says, I told Dr. Dehlinger this was legal, I have an excellent defense, and I would expect to win that. If I have only Dr. Dehlinger says that someone told me that and they're not going to testify, you're just going to have to take my word for it, you're looking at a conviction. They needed Tara LeGrand. But Collis Red could have done it too. Collis Red was precluded. What you have is the person who's heavily committed with all three of these people. We don't know the relationship between them and Kuzel except through Englehart's words, but we do know.
What do you say about the fact that before he accepted the representation, there was this meeting and discussion, and everybody agreed that she was not going to be called?
What you have is a lawyer.
And in fact, he said, if she's going to be called, I'm not in this case.
He does say that.
And the judge found that to be accurate and true.
Well, yes, the judge did, and I can't say. I think it was an abuse of discretion finding that Mr. Englehart was telling the truth when he swears under
you have
oath.
a clear error standard here, don't you? It's not an abuse of discretion. Credibility determination.
I believe it's abuse of discretion.
As to whether a witness is truthful or not?
I believe so. On this is a mixed case of law. It's de novo on law, and I believe if I'm mistaken, I'm mistaken, Your Honor. I believe it's abuse of discretion on this mixed case of law. I have a case saying that, and if it's wrong, I apologize to the court. What we have is a situation where Englehart was told by the government, you can't represent all three of these planners. The government knew about it. Not counsel present, but the counsel before him knew about it. And he said, you can't represent Red and LeGrand and Kuzel. One of them is more likely innocent. The other two are more likely guilty. You're going to have to pick one. Under oath in an affidavit, Mr. Englehart says, I represented all three of them. They were my clients. Under oath on the witness stand, he said they really weren't my clients. It didn't rise to the level of being clients, even though he advised Mr. Red to plead guilty, and even though Mr. Red says that they had 3 hours of telephone conversation on the case. Tara LeGrand would have had to be consistent either with her plea or her original statement, and both times she told Dr. Dehlinger and everyone in the audience that this was perfectly legal, and she gave her CPA reasons why. Same thing with Collis Red, same thing. Dr. Dehlinger was in the audience with both of them. He took their words for it, and when there was a raid, some people went to other CPAs and they refiled for them, and some people went to Tara LeGrand, or she was assigned to them, and Tara LeGrand kept them in the program. Had Tara LeGrand not done that, Dr. Dehlinger wouldn't be here today, wouldn't have been incarcerated for 4 years. He would have gotten another CPA had she not been there to tell him it was perfectly legal at all times. That part of the testimony she would give, unquestionably.
I think your time is...
Yes.
You have reserved a little time.
Yes, Your Honor. Thank you.
Mr. Lombardi?
Good morning, members of this honorable court. I'm Kevin Lombardi from the Department of Justice Tax Division on behalf of the United States. The government submits that this court should affirm the district court's order, which found that the defendant has not made a successful motion under Section 2255. Specifically, the court made findings and credibility determinations that found that there was no link between trial counsel's decision not to call the 3 witnesses at trial and between any prior relationship that he had with those individuals.
That's belied by the record itself. The fact that he would start off by saying, I'm not going to call her, and almost conditioning that on representation, that fact alone belies what you just said. His prior relationship with her set the course for his relationship with his new client. How does the record not establish that? Answer that question. How does the record not establish that? He started off by saying, I can't imagine a lawyer saying, listen, I haven't even all the facts of your case, but if it involves calling this person, I'm not even going to represent you. Tell me how that has not set the course for his representation for the doctor.
I don't think it does, Your Honor, because
Why not?
he knew, he was well familiar with Tara LeGrand after years of being familiar with the
Certainly he
trial in
was.
Seattle.
Yes, that's the substance of the conflict. Go ahead.
So he was well familiar with Tara LeGrand and her case and her testimony and what she would be able to testify, and more particularly with the disposition of her case, which had happened well before the defendant's trial, Your Honor.
Well, let me ask you this same question. Is it the government's position that if an attorney tells the client at the outset of the representation, I have a conflict, something more than was said here, to be sure, I have a conflict with witness X, and if you think that witness X is necessary, you shouldn't hire me? What do we do about that if ultimately the client wants to hire witness, wants to call witness X? Is there a conflict?
The predicate there, Your Honor, there was no conflict established at that time. What Mr. Engelhardt said is, here is my trial strategy for this case. If you want this witness, if you want to pursue a different strategy, I'm not the lawyer to do it. And in that case, I think we would
Well,
submit...
I understand he didn't say that. And you think the situation would have been different if he'd said, I'm not the lawyer for you because I think there might be somebody down the road might think there's a conflict if I call this person and represent you. You think that your case would be different?
That could be a different situation,
Why?
Your Honor.
I mean,
Well,
in other words, you think that there would be a basis for 2255 here?
not necessarily if the decision would have been in the end same. If the decision not to call her would have in the end been the same, Your Honor,
Well,
there would be no
it was the lawyer's
conflict.
decision not to call her, right? So exactly the same facts, except we slightly changed the beginning conversation, where he says, I think there may be a conflict, so if you want this witness called, remember that I'm not your man. And then the facts unfold as they do here, where the client says every now and again, and when are we going to call Tara? And he kept saying, remember, we're not calling her. So does that give her a basis for 2255?
That could change the conflict analysis, but I don't think it would change the 2255 determination. The defendant
Well,
would
the
still have...
conflict analysis is the basis for the 2255, right?
It's the beginning of the analysis,
Well,
Your Honor.
that's the grounds for granting 2255 relief, whether you have set forth an adequate ineffective assistance of counsel argument on the basis of conflict. Isn't that right? That's what we have here. That's what we'd have in my hypothetical.
You must also show an adverse effect on the relationship, Your Honor.
Well, but it all comes from the conflict in the lawyer-client relationship. That's all I'm asking you. So how would that be different? How would my hypothetical be different, come out to a different conclusion? That yes, there was a conflict of interest and this person should get a new trial? Or maybe you don't think it would. I just am trying to...
It would not be different, Your Honor, because there would still need to be that adverse impact. If calling that witness was not good for that client as a matter of trial strategy, there's no 2255 claim.
Well, I understand, but you're assuming it's a matter of trial strategy, and my hypothetical is he's saying right out, it's a conflict for me to call this witness.
I don't think he is, Your Honor. I don't think he said it is a conflict.
In this case, he did in the hypothetical, and what I'm doing is asking you is, would that make any difference in the argument that he was denied ineffective assistance?
Okay, I understand, Your Honor.
I'm sorry, I must have been obtuse.
It's going down a hypothetical, but if the lawyer cut off a defense that the client wanted to pursue, and that arose from a conflict of interest, that I believe
That's
that
exactly
might establish.
what happened. He cut the defense off. I mean, when I practiced law, I thought that the facts ought to dictate what you do in a case. But at the onset, you tell somebody, I am not going to call this person. And that's the condition upon which you have to retain me. Then all along, for example, did the doctor testify in this case?
He did, Your Honor.
And the doctor said he was told it was proper, right? Correct?
He testified
Didn't the doctor
essentially-
say he was told that this was legit? Yes or no? That's easy. You know the record.
Testified that he believed that it was legitimate.
And he was told that it was legit. Did he say that?
He did say that.
Okay, all right. So then the lawyer couldn't have put him on unless he believed, at least in good faith, his client was telling the truth. Correct?
That's correct, Your
So
Honor.
therefore, whatever he heard from LeGrand must have been that LeGrand told him that it was proper, right?
In 2002, that's what the defendant's testimony was that Tara LeGrand told him that it was proper.
And the
in
lawyer knew
2002.
that, right? The lawyer knew that that would be her testimony. I mean, presumably, in other words, it's unethical to put a client on the stand you have no good faith basis to believe that they're telling the truth. So why wouldn't she be appropriate to say, didn't you tell my client that this was appropriate?
It's a potential strategy.
Potential? It's the very essence of the strategy. The only way you are convicted, you have to willingly, it has to be willful fraud. That's the whole, that's the French would say, that's the piece de resistance, eh? No?
I don't agree, Your Honor.
Okay, you don't agree. Tell me why you don't agree.
Putting her on the stand was also not viable in this case.
Why not?
Well, one, she had given prior inconsistent statements under oath concerning the legitimacy of
Well,
the
the
program.
government does it all the time, and they say, who do you expect us to call? Choir boys? They always call people who...
Sunday school teachers.
Yes, Sunday school teachers. Yes, so he has a long jacket. What difference does it make? Right now, he's telling the truth. You do it all the time, United States government. Well, you mean defense can't do it? It has to be a choir lady or choir girl before she can testify? No, you told my client and you duped them. That's a viable and almost only defense that he would have, other than his lone voice in the wilderness saying, I thought this was correct. And he would tell them, I'm not going to call her. I don't care what the facts dictate later. And that's the condition from which I represent you. And that's not a conflict. And the government said he had a conflict on the record and wouldn't let him represent all three of them. Now you backtrack it. You represent the United States government. That's a high standard. Not just to get the convictions, but to try to get in terms of what's appropriate under the Constitution. But how can you say that's not a conflict?
It was not an actual conflict in this case. It did not rise to anything that had any impact upon his performance.
One thing I haven't heard you talk about is that the Supreme Court law on granting 2255 relief is pretty difficult test to meet. And there's a lot of talk about trial strategy and reasonable trial strategy that supports what the lawyer did. And there were a lot of findings by the district court here about that, about there would have been alternatives to this testimony from other people that were better. And
That is correct.
You don't have anything to say about any of that today.
I do, Your Honor. The defense lawyer's trial strategy was to introduce that the defendant relied on, in good faith, upon what was told him. Another client of the programs was called at trial to testify about what participants in the programs were told. In addition, there was an expert witness that essentially testified to what the defendant now says he would have wanted a triple Anderson's Arc planner to testify to, was that there was nothing wrong with the structure of the programs.
Well, the lawyer that is accused of giving ineffective assistance here, did he testify in the 2255 proceedings?
Yes, he did, Your Honor.
So what does he say his trial strategy was?
His trial strategy was to show that the defendant believed in good faith that the programs were legitimate, that he participated in.
Why didn't he call the witnesses that the defendant now says should be called?
The most logical witnesses to call would have been those who introduced the defendant to the program and upon whom
I'm not sure.
he interacted.
I don't mean to cut off your answer to Judge Motz, but I thought the record was perfectly clear that he knew from his half-decade of involvement with these people that he was not about to call a single planner as a defense witness in this trial. Isn't that perfectly clear?
That is correct, Your Honor.
He knew everything there was to know about these planners, didn't he?
He did, Your Honor.
He represented Miss LeGrand. he was uniquely positioned to know what these planners were up to and what truthful testimony from them would entail. I mean, I don't want to put words in your mouth, but I would have thought that that would have been a part of your answer to Judge Motz.
I certainly would have gone there, Your Honor, and you stated it better than me.
You agree with what Judge Davis said, correct, right?
I agree, Your Honor.
That means, and for the very same reason, that's why he's the worst person to have for the client that he had.
Do you agree with that?
I do agree with that, Your
Mr.
Honor.
Mims says he would have put her on knowing nothing about her except that she testified one way and pled guilty months later, totally contradicting herself. So I guess you had a choice between Mr. Mims and Mr. Engelhardt, who knew everything about the planners and what they were up to, and a lawyer who had no conversation with her in advance whatsoever. All he had was the two transcripts.
And to your point, Your Honor, he was also present in court when Gary Kuzel was a defendant at that trial, when Richard Marks, with whom the defendant primarily interacted in joining Anderson's arc.
And the he is the lawyer here? Who is the he? He was also present in court.
Oh, Mr. Engelhardt.
Counsel, would you allow me this? Assuming what Judge Davis said, assuming that's all correct, that he knew exactly their profile, right? So let's assume that. But you have a client that presumably you believe because you put them on. There is a such thing as that sometimes you have to take on witnesses and you call them adversely, right? Are you familiar with that term? That concept?
I understand
Right.
where you're going,
Sometimes
Your
you
Honor.
have to do that, correct?
Correct.
He wouldn't be the lawyer that could adversely take on LeGrand because of his prior relationship with her. Matter of fact, we can't even make him tell us everything he told her because that's attorney-client privilege. How in the world could he adversely put her on? He could not do that, could he?
Well, one, for Your Honor, she did execute a complete waiver in this case, including discovery materials and work product in the prior prosecution. So this is a case.
So he could have put her on adversely.
I think he could have, Your Honor, as long as.
And
Why are you so tentative? Of course he could have put her on. He had a waiver.
And why didn't he?
Because it was not good for the defendant.
How do you know that?
Well, in the facts of this case, she would have offered no defense to counts 2 and 3 of the indictment. Those crimes were completed before the defendant interacted with Tara LeGrand in 2002. So the reasonableness of the defendant's reliance
Well, she
upon...
couldn't have testified generally what their scheme was and how they duped people and sent them to seminars. That wouldn't have been helpful?
There were other means to get the same information.
Well, he didn't
Your
call
Honor.
Red, you're right. And the government didn't indict him, correct?
That's correct.
Why
We
is
did not
that?
indict him.
Why not?
I'm not sure, Your Honor.
You're
I
not
was
sure?
not
Don't
involved.
you know the case?
I know the
You
case.
come here, so, I mean, you're the government, and you're Red, you don't even indict. So why didn't he put him on? He's obviously a truthful, honest person, because so much so he wasn't indicted. Why didn't he call him?
Well, the record establishes here that Collis Red had no knowledge of the defendant's tax returns, and he also had never met the defendant. It would not have been a reasonable strategy to rely upon Red as the person who gave you your good faith belief in the program.
Do you agree with Judge Gregory? I think you've agreed with him twice, once explicitly and once implicitly, that a criminal defense attorney under the Sixth Amendment in federal court can only put his or her client on the stand if the attorney believes the client?
I'm not-
One count, I said good faith.
Does an attorney have any role to play in whether a criminal defendant takes the stand? Obviously, ethically, defense attorney cannot knowingly offer false testimony or evidence to a court, but under the Fifth Amendment right to remain silent or to testify and the related Sixth Amendment right, isn't there a major difference between the role of the lawyer in choosing which witnesses to call as opposed to whether the client himself or herself takes the stand and testifies?
There is, and if I'm following you, Your Honor, it's the client's decision whether to testify or not.
Absolutely. I mean, sometimes the defense lawyer has to stand there and say, tell the ladies and gentlemen of the jury your story, right? That's the best a lawyer can do given certain level of knowledge. But it's exclusively the lawyer's role as the advocate for the client to decide which witnesses take the stand, right? Isn't the law clear?
That is correct, Your Honor. And in this case, I think no matter who was representing Tara LeGrand, that person would have advised Tara LeGrand to invoke her Fifth Amendment
But
rights.
you're coming at it, I think, in somewhat of an awkward position. The point is, we don't care what Dr. Dehlinger wanted by way of witnesses, do we? That's not his call. He's the defendant. But it's the professional judgment of the lawyer who decides in a defense case who takes the witness stand. I thought the law couldn't be more clear about that, in contrast to whether the defendant himself takes the stand, as to which the lawyer has no say whatsoever.
That is correct, and that dovetails in with the tactical judgment of the defense lawyer in this case. What witnesses you call also is one of the most, it gets to the very core of trial
And more generally,
strategy.
what evidence you put on, and whether you put on any evidence apart from your client's testimony.
That is correct.
Yeah, but the standard for judging an IAC claim will look at who you put on and what your client told you about who was available and who had appropriate testimony, and you're not putting them on can probably be the basis for ineffective assistance, notwithstanding normally the lawyer's role in deciding who you put on. Because otherwise, you would eviscerate an IAC claim if you said, listen, I'm the lawyer, I put on who I want to put on. And that's the end of the case. That's not the end of the case. If this is the law, then basically Mickens is extended to the point of distortion of the whole concept of conflict. Because all you have to say is, yeah, I had a conflict. The government said I had a conflict before. I represented before, but I decided early on, I told the client, I'm the lawyer. I'm not going to call it. And that's the condition, period. So there's no more conflicts now because you basically have gotten your client to waive it if it exists, right?
I don't agree.
Well, why not? Wouldn't that be the logical extension of what this case would represent?
Well, when you had said that there was a conflict then and it always existed, that is not necessarily the case here. A conflict that was disclosed by a prosecutor in 2002 does not necessarily inhere during trial in October of 2007.
What changed in terms of his knowledge of what she had to say and what the role would be in defending the doctor? What changed?
He was intimately familiar with what she would say. He had represented her throughout the trial and her guilty plea. And so he was intimately familiar, and he, meaning Mr. Engelhard, as to what she could offer at trial.
And that then you have to assume that everything he knew about her and what she told him would not be favorable to the doctor. That had to be the assumption, right?
Not necessarily, Your Honor. If it was bad trial strategy to put her forth as the proponent of the defendant's good faith defense, there would be no 2255 claim.
Suppose she told him, yeah, you know, that's what we did dupe him. We told him the whole time this was legitimate, and he knew that, and he didn't put her on. Would that make a difference?
It could make a difference. It's not the facts
Davis said
here.
it's his choice. He can choose not to put her on. What difference would it make? Yeah, she told me the whole time that she duped this man completely, but I'm not going to put her on because I don't want to put her through the pain of testifying. So what difference does it make if it's totally the lawyer's call?
Well, there's no evidence in this case, Your Honor, that she would have said one thing or another.
That's the point is. That's why Mickens, with all due respect to the president of this court, is so wrong. You can't even make the lawyer tell you what she told him. That's the problem. I don't know why we go so far to try to get around what is a basic constitutional right. You can't make him tell you what she said because that's attorney-client privilege. How in the world can you ever establish a case like this when you can't even make your lawyer tell you what that other person even told him or her?
But in this case, Your Honor, there was a waiver.
Go ahead.
In this case, Your Honor, there was a waiver.
So the lawyer did testify as to what he would have said. what his assessment of this witness was.
The lawyer did testify.
No, he
Mr.
stopped. He did not tell everything. Didn't he say some of it was confidential?
I'm having a little bit of trouble finding. The lawyer, Mr. Engelhardt, did testify at the 2255 hearing, if that was the question from Judge Mott.
But not as to everything she was told. He was told by her.
We don't know the scope of everything.
And did he say some of it
Anything
was
relevant.
attorney-client privilege? Did he not?
My recollection of the record is he never invoked attorney-client privilege.
He did not say her conversations, some of the conversations were privileged, he felt was privileged?
I'm not aware of that in the record, Your Honor.
If it is, would that make a difference?
In this case, no, Your Honor.
Oh, wouldn't he make a difference? Okay, all right.
Okay, thank you very much. Mr. Mins, what would have adequately waived the asserted conflict here?
Well, the law is clear on that in the American Bar Association, the South
Fine,
Carolina.
just tell me, because I'm not clear, so you
Yes.
just come right
You
out and
must
tell me
give
what it
a
is.
full and complete disclosure to the client. You must have the ability to believe there is no conflict that you can waive. In other words, it has to be waivable, which this isn't. There's never been a case where the person who prepared the return and the person who signed the return at the advice of the preparer has ever been allowed to represent the same person. There's no recorded case. But assuming,
He was representing both of them at the same time?
yes, well, he absolutely was. He was the only attorney of record for Legrand before
Would
this,
it make
after
any-
this,
no, no,
during
no,
this.
Okay, just bear with me for a
Sorry,
second.
Your Honor.
If he wasn't representing her at the time that he was representing the doctor, would it make any difference?
I don't think so, but his testimony on that,
Well,
Your
could
Honor.
you give Judge Motz a more thorough answer to that question?
Yeah, the first one or the second one, Your Honor?
Sequential representation.
Well,
If this is a case of sequential representation, is there any difference in the law or?
the law looks more harshly on simultaneous, but sequential is also looked on pretty harshly.
So if this is a sequential case, what's our standard here? What are we looking for?
If this is a sequential case, which it is admitted to be sequential, as a matter of the testimony and the government's admissions on this.
Fine. If it's a sequential case, and it is a sequential case, what's the standard?
The standard is that if there's any possible conflict, and the sequential nature of it, as a matter of law, is a potential conflict. He has to explain it to the client, get the client's release in writing. He did not get the client's release in writing, and there's no evidence of any explanation. Did
Did the doctor testify about this?
Yes, Your Honor.
And did he testify that the lawyer never mentioned this to him? This beginning conversation, if you want me and you want to call it, you can't have me if you want to call this witness.
No, this is the testimony. It's not that specific. The testimony of the doctor is that he constantly wanted Tara
I
Legrand.
understand that testimony. I'm asking about the testimony about the conversation at the beginning of the representation.
I don't think that's in the record, Your
The
Honor.
doctor never testified one way or the other whether he had this conversation with this.
Oh, he said that he did not tell him, that he didn't explain conflict to him at all.
Did the doctor testify that his lawyer said to him that if he wanted to call Tara Legrand, he should get another lawyer?
Specifically, what he said was that he did not believe he was the lawyer to call.
Tara
There's
Legrand.
there's an email that if he called Tara Legrand, specifically what he told him was, if you call Tara Legrand to the stand, I will leave you in the case. And the testimony of the co-counsel who had never tried a case before a jury in his life was that he said that, yes, I'm quitting the case.
He said, I'll leave you in the case.
Yes, sir.
His lawyer.
Yes. And
When did that occur?
this occurred during this
middle
was
of
either a
trial?
couple of
Out of
days
the
before.
blue?
Well, they were constantly exploring this. Dr. Dehlinger was
Oh, they
constantly
were
asking.
constantly talking about this.
Yes, Dr. Dehlinger was
Talking about
demanding
it.
Tara Legrand.
The doctor acknowledges that the lawyer is constantly saying to him, no, we shouldn't call this person.
That is true, Your Honor. And then the co-counsel
He
says,
said,
well,
no, he won't call him, didn't he?
he says he won't call him. And the
Co-counsel had a conflict as well, right?
co-counsel said, I'll put her on, and lead
Co-counsel
counsel.
had a conflict as well, right? Because his partner represented Legrand.
I don't disagree with that, Your Honor, at all.
You don't disagree?
Is that your argument here?
No, it is not. The lead counsel called the shots. Co-counsel had never tried a case before in his career in front of a jury. He was pretty much doing whatever Englehart told him to do. Englehart threatened to leave when co-counsel, and this is in the record, said, I'll put her on. He really wants her on, and I'll put her on. And he said, I can't. She's my client. And he was simultaneously representing her. There's constant communications with her and him the eve of this trial, after this trial. The only time that he wasn't representing her really was when she was getting legal advice, and he says, you know, I'm going to have to be paid. I'm going to have to file for CJA funds again. There's another huge conflict. This lawyer was getting CJA funds. He was getting paid by Tara LeGrand. And he was getting paid by AAA. He couldn't afford to put Tara LeGrand on the stand. He might have been facing his own charges.
So let me ask this, if I may. Your submission, I take it, is that you're relying on a contention that the conflict here was inherent. You believe this case is Nicholson.
Pardon?
You believe this case is Nicholson.
Yes,
Is that right?
there's an inherent, well, not exactly, not on all fours, because there's more ethical.
Well, how is it different?
Well, there's more ethical violations than I've seen in any published case
Well,
ever.
we're not interested in ethical violations. We're interested in Sixth Amendment standards. And
Yes.
the fact of the matter is, Mickens does cut back on Sullivan.
Yes,
You,
but
you agree with that, right?
Yes, I
mean,
do.
the bar was shocked when Mickens came out because everybody thought Sullivan meant any conflict of interest, anytime, anywhere, of any nature, you get post-conviction relief. And the Supreme Court came in and Mickens and said, no, we didn't really mean that. Actual conflict of interest is far more nuanced. And so, as I understand Mickens, the question is, what would a non-conflicted lawyer have done differently from what Englehart did in this case?
he would have put on
Now,
all.
you say you would have blindly put LeGrand on the stand with no idea what she was going to say, other than these two transcripts, which conflict with each other.
No, Your
And you
Honor.
would have done that because your client insisted that you do it.
I called her at the 2255 as an adverse witness. Englehart would never do that, never could do that. And
After the
I would.
fact.
Pardon?
I'm talking about the trial.
I would have put her on the trial, yes, as an adverse hostile witness, and I would have cross-examined her on her under oath testimony. She was either lying or telling the truth. Either way is exculpatory. And with Mickens, Your Honor,
The way it's exculpatory?
yes, it's exculpatory when someone
You have no
entraps
idea.
somebody.
You have no idea what the witness is going to say, and you're willing to stand here and say to a United States Court of Appeals panel, either way, it's exculpatory.
I know exactly what she's going to have to either say or deny. She's either going to have to agree with what she's already said under oath, or she's going to have to deny it. Either way, it incriminates her.
She said everything under oath. So she's going to both admit and deny.
But
That is the problem with her as a witness, right?
the problem with any criminal as a witness is that they are unreliable inherently. But the problem with Tara LeGrand is she was sealed. She was in cement with her testimony in her own trial and her testimony that she had defrauded people like Dr. Dehlinger in her plea bargain. So either one worked. Either one worked.
That her waiver was ineffective or unenforceable?
Well, I don't represent her, but in all probability, that would be between her and her counsel.
No, I'm asking the question, do you contend before us that her waiver, she exposed herself totally, as I understand that waiver. Do you have a contrary view to that?
Yes, Mr. Englehart, on her behalf, pled Fifth Amendment 30 days after this trial in another proceeding. So he was saying to the Seattle, Washington court, this woman cannot testify, she must plead Fifth Amendment.
How does that answer my question about the enforceability of her waiver?
When he achieved the waiver, knowing that he was never going to allow her to testify, it was not an enforceable waiver. If he believes he shouldn't testify, it's not an enforceable waiver. If he believes she shouldn't testify, it is. But he apparently can't go both ways. And his waiver, no, it was unethical to even ask her. And she was the only one he asked. He didn't get a waiver from Red. He didn't get a waiver from Kosel. He didn't get a waiver from Dr. Dehlinger. He didn't go back to Dr. Dehlinger when he supposedly re-represented Tara LeGrand, and he didn't get another waiver from Tara LeGrand. All of these are required by the ethics in all of the states. And in Mickens, And I disagree with the Mickens decision, too,
Well,
but
it's fine to disagree, but, you know.
But it's distinguishable, isn't it?
And
Yes, it is,
came from
absolutely.
it was an on-bank decision of this court, so there were some people on the panel in front of you that also agree with you that Mickens is wrong.
I know, Your
That
Honor.
doesn't make any difference, it's the
Well,
law of the land.
there is something that does make a difference in
Well,
Mickens in the
I
oral
think you
argument.
better, failing questions by my colleagues, I think you better finish with one sentence. Your red light's been on.
5 of the justices questioned the ethics in the Mickens case at the Supreme Court, so they were unsettled. It was a very tight case even at the Supreme Court. It
Okay,
could have
that's
gone
a
either
sec-
way.
Do you have any?
I just want to follow, the question is that the difference in Mickens was the sequential representation had nothing to do with the offense that it was charged. I remember the case. It was a matter had nothing to do. Here, that's not the case. Whether sequential or simultaneous, it was related to the same case. There's a big distinction there.
That's absolutely correct, Your Honor. Thank you.
Do you have any more questions, Judge Gregory? Judge Gregory?
No.
Thank you very much. We will come down and greet the lawyers and then go directly to our next case.